Good afternoon. My name is Nate Kazmarek. I am the Deputy Director of the Federalist Society's Article 1 initiative. The initiative is dedicated to the development of a theory of the role and practical goals of Congress that stem directly from core constitutional principles. Today's luncheon is just one of the many events the Federalist Society has planned here on Capitol Hill and across the country. On behalf of the initiative, I want to thank you all for joining us. At the outset, I'd also like to thank Senator Ron Johnson and his staff for sponsoring the room for today's event. As you may have noticed from your program and from our panel up here, we are playing short-handed this afternoon. Professor Julian from Hofstra University School of Law. Not sure what that was. Professor Koo had a last-minute conflict which precluded him from flying down this morning. But even without his valuable presence, I think you will agree that we have a great panel. And the topic of executive and legislative war powers seems particularly appropriate given that we just celebrated our nation's Independence Day. After more than 200 years, our government has developed a track record regarding starting wars and the use of military force, which can be measured against the founders' views and the Constitution. It's good to ask, how has the framers' understanding been followed, and in what ways has it been ignored? And do the founding principles regarding these topics still have application to our modern era? To help us navigate these and other important questions, we're pleased to have with us Andrew McCarthy, who is a senior fellow at the National Review Institute and a contributing editor at National Review. He is a former assistant U.S. attorney for the Southern District of New York. He led the 1995 terrorism prosecution against Sheikh Omar Abdel Rahman and 11 others for waging a terrorist war against the United States, including the 1993 World Trade Center bombing and a plot to bomb New York City landmarks. He has also contributed to the prosecutions of terrorists who bombed U.S. embassies in Kenya and Tanzania. He writes regularly for PJ Media and The New Criterion, and is a New York Times best-selling author of many books. And we're also pleased to have with us former Congressman Mickey Edwards, who is the Vice President and Program Director for the Rodel Fellowships in Public Leadership he's the Vice President and Program Director for the Rodel Fellowships in the Public Leadership at the Aspen Institute. He was a member of Congress for 16 years, representing Oklahoma's 5th Congressional District. He served on the House Budget and Appropriations Committees and as chairman of the House Republican Policy Committee. After Congress, he taught at Harvard's Kennedy School of Government and Princeton's Woodrow Wilson School of Public and International Affairs. He's on the board of directors for the Constitution Project, where he has chaired task force on judicial independence, government oversight, and the war power. He is the author of numerous articles and books, and his most recent book was published in 2013 titled The Parties versus the People: How to Turn Republicans and Democrats into Americans. Before I turn it over to our panel, I wanted to note that following the panelists' remarks, we will have Q&A, so please think about questions you'd like to ask our panelists. With that, Mr. McCarthy, the floor is yours.
Well, thank you so much, Nate, and thank you to the Federalist Society for the kind invitation. I have about 15 minutes of opening remarks that, in light of Julian's absence, I'll try to squeeze into 20 if I can. But as we gather on Capitol Hill today, the United States Armed Forces are engaged in combat operations in several global hotspots. In Syria, we have not only conducted attacks against the regime without any congressional authorization, we are now occupying territory as well. Ostensibly, we're there to fight not the regime or its Russian and Iranian allies, but the Islamic State jihadist organization, also known as ISIS. But to the extent that is a legally authorized conflict, it is against an enemy that arguably did not exist at the time that the relevant authorizations of military force were adopted about 15 years ago. Now, you could say, as we have been saying, that ISIS is merely a breakaway faction of al-Qaeda. It began as the terror network's Iraqi franchise, and consequently it is covered under the existing AUMF. This, however, ignores the inconvenience that al-Qaeda, along with its allied Islamist factions, is also fighting ISIS and the Assad regime in Syria. Essentially, the enemy that we started out fighting after it attacked America in 2001, and that still regards the United States as its mortal enemy, is nevertheless fighting in Syria alongside the rebel elements that we support. In that sense, the situation mirrors our misadventure in Libya. That was another recent conflict in which a president, without congressional authorization, launched an aggressive war against a foreign sovereign that not only posed no threat to the United States, but which was actually regarded as an important counterterrorism ally. And that was because, for all its many flaws, the Gaddafi regime was providing us with intelligence about militants in places like Benghazi and Derna, which were the Libyan support hubs for the anti-American jihad in Iraq and Afghanistan. That is to say, in Libya, we initiated an unnecessary war without any debate among the people's representatives, much less any congressional authorization. The result was a catastrophe: the undoing of a counterterrorism ally in a dangerous neighborhood, the empowerment of our jihadist enemies, a failed state, and an administration reduced to absurd rationalizations about how its bombardments against regime targets were somehow not acts of war. It is tempting on this record to draw the conclusion that modern practice has superseded the Constitution's division of war-making powers between the executive and the Congress. But when we get down to brass tacks, this simply is not true. And it's not true for a reason that is often forgotten in our war powers debates, which are dominated by lawyers. The debates tend to take place under the auspices of legal academic institutions or organizations like my friends and colleagues here at the Federalist Society who are hosting us today. The reason is we are a body politic, not a legal community, at least in the main. For any free society to flourish, it must, of course, be undergirded by the rule of law. But the Constitution is basically a political document, not a legal one. It is the assignment and division of political authority among actors who compete and collude depending on the attendant circumstances. This is critical because war is a political exercise. Politics by other means, as Karl von Clausewitz memorably put it. There are legal elements to it, but it is basically a political endeavor. The use of government power, in this instance force, against a foreign enemy in order to break the enemy's will. Though you wouldn't know it to listen to most war powers discussions, there is a limit to how much war can be judicialized, or how much it can be subjected to antecedent legal rules and procedures. A state of war, after all, is the antithesis of our domestic peacetime footing. It is the proud boast of our domestic legal system that we would prefer to see the guilty go free than have a single person wrongfully convicted. Thus, we presume against the government. The accused is presumed to be innocent and has no burden to prove anything. The government must meet weighty standards of proof to conduct a search, to obtain a wiretap, to make an arrest, to convict a defendant. Our bottom line is we would rather see the government lose. That is, justice is not conviction of the guilty, it is forcing the government to meet its strict burden of proof before liberty is removed from one of our fellow citizens. War is entirely different. In war, we don't and we can't want the government to lose, and we cannot give the enemy the presumption of innocence. In war, it is always in the national interest that the government prevail. Yes, our troops are the world's best trained and most disciplined, and we demand of them adherence to the laws and customs of civilized warfare. But the highest national interest is to defeat the enemy and to achieve whatever objective was so vital that it was worth going to war over in the first place. War is thus a very different paradigm. Far from legal niceties, it is driven by the public's perception of threats to the homeland and to vital American interests. Our division of war powers is a reflection of this political reality. As we discovered painfully in Vietnam and to a lesser extent in Iraq, a war effort needs strong political support to be successful in a democracy. If there is not public consensus that our security is at risk or that high-order American interests are at stake, support for war at home and in Congress will flag. At that point, we can debate until the end of time whether the use of force was lawful and authorized. The only salient point will be that the public does not regard the war effort as a necessary sacrifice of blood and treasure. That will be the practical and dispositive test of a war's legitimacy. Our Constitution's war powers are geared in just that way and for just that reality. The Constitution vests in Congress the power to declare war. The executive, however, is chiefly tasked with our national defense against foreign threats, and it is for the commander-in-chief to prosecute war. This means that when the United States is under attack or a real threat of attack, no authorization from Congress is needed. The president may take whatever military actions are necessary in order to quell the threat. Even under these circumstances, however, congressional authorization is desirable. And it becomes not only desirable, but increasingly essential as the immediacy of a threat fades. For congressional endorsement of combat operations not only reflects public support for the war, it further defines the parameters of the conflict, including, critically, who the enemy is. This is necessary because it delineates the operations of the laws of war, determining who may be regarded as an enemy combatant, subject to lethal force, detention without trial after capture, and potentially even trial by military commission if provable war crimes have been committed. A congressional authorization controls where and against whom military operations may be conducted as wars go forward. Here is the main point. The further removed the use of force is from an identifiable threat to vital American interests, the more imperative it is that Congress weigh in and either endorse or withhold authorization for combat operations. The less obvious the peril, the more important it is that Congress use its other constitutional authorities, particularly the power of the purse, to ensure that military force is employed only for political ends that are worth fighting for, and critically, that the public will perceive as worth fighting for. Now, it's fair enough to say that our contemporary practice has not conformed to the constitutional guidelines I've just outlined. As a practical matter, we have permanent military forces, and there is no stopping a president from ordering them into battle. As we've noted, President Obama did not seek congressional authorization for the Libya campaign, just as President Clinton did not seek it for the bombings in the Balkans, and President Reagan did not seek it before invading Grenada. After insisting as candidate Trump that Obama needed congressional assent to attack regime targets in Syria, President Trump has attacked regime targets in Syria without congressional authorization. Congress's war powers have seemed not to be too much of a hindrance on the executive. Nor does Congress's power of the purse seem to have much bite. It is simply a political reality, it is common sense, that the American people have a deep attachment to their sons and daughters in harm's way, regardless of their commitment or lack of commitment to a war and its objectives. Congress may disapprove of a unilateral presidential use of force, but unless the public is not merely indifferent, but actually deeply opposed to American participation in a conflict, lawmakers will be very leery of being seen as cutting off support for the troops. So here is the dynamic. The president has a relatively free hand, and Congress abdicates its responsibilities, content to wave the pom-poms when things go well and to excoriate the incumbent administration, but not cut off funding when the going gets tough. Still, we can see the Constitution at work as a political document, even if the resulting legal arrangements are untidy. The lack of political support that induces presidents to refrain from seeking congressional authorization also operates as a severe political impediment to presidential war-making. The perception that war-making is of dubious legitimacy serves to rein in executive ambitions, and over time, Congress does assert itself. We saw how this worked in Iraq. There was very strong public support for the mission of removing Saddam Hussein on the grounds that were very powerful in the post-9/11 environment, that he had weapons of mass destruction and might be inclined to share them with jihadists. The mission was sufficiently popular that congressional Democrats, with the 2004 election on the horizon, sought out the opportunity to vote in favor of authorizing force. But after a swift and successful toppling of the regime, it became increasingly evident that there was another very different and very ambitious war aim. It was more a Washington enterprise than a mission the American people believed in. It became prioritized when weapons of mass destruction were not found in the quantities advertised. This was the effort to sow Western democracy, principles, and institutions in an Islamic Sharia society that was hostile to them, hostility that grew more intense as the joy of liberation from Saddam transitioned into American occupation and a savage civil war between Sunni and Shiite factions. Alas, we did not learn and apply the lesson of this folly in Libya, and I fear we are well on the way toward making the same mistakes in Syria, where the consequences of folly could be disastrous given the players involved in this complex, multi-layered conflict: Russia, Iran, Turkey, and so forth. President Trump gave a very interesting speech in Poland yesterday about preserving Western society, except he didn't call it Western society. He referred to it instead as Western civilization. He was right, just as Samuel Huntington was right. Our conflict with radical Islam, with what I call Sharia supremacism, is a clash of civilizations. To prevail, the West has to decide that the West is worth defending, and we have a lot of work to do to repair that self-perception. But we also have to realize that the enemy is a product of a rival civilization with starkly different principles. It is not enough to say fundamentalist Islam, which is the mainstream Islam of the Middle East, does not wish to be westernized. It considers the intrusion of Western armies and institutions to be a deep provocation, even if we see ourselves as do-gooders who are just trying to improve people's lives. This is a product of spending a generation in willful blindness of our enemies' animating ideology, and that could be the subject by itself for another symposium. The point that is relevant to constitutional war powers is the political imperative of public support for military operations. If there are vital American security interests at stake, the American people will be on board. Congressional authorization and endorsement will then make it possible to achieve crucial military victories. Americans, however, are simply not interested in trying to democratize Islamic societies through military force. On this score, it is essential that Congress do its job. Demand that any president who lurches into these conflicts seek congressional authorization for clearly stated objectives and satisfy the people's representatives that we are pursuing real security needs, not conducting a sociology experiment at the expense of the lives of our best and bravest young people. As a practical matter, the Constitution may not be able to prevent an overly ambitious and adventurous president from enmeshing us into conflicts against our interests. But congressional war powers can still have a very important say about both the legitimacy of the use of force and therefore about its extent and its duration. Moreover, where the use of force is clearly in America's vital interests, congressional war powers used to issue a powerful endorsement of a clear, necessary mission can help us achieve something that's actually eluded us since 1945: victory. which is a word that's barely even spoken when we speak of American war powers. Thank you very much for your attention, and I look forward to our dialogue.
So I'm very high tech. I had to learn how to push to turn on the microphone. Well, I'm delighted to be here, have a chance to give some different views. I think that I agree with an awful lot of what you've said. I want to maybe come at it from a little different angle and to try to wrestle with some things in my mind. You mentioned my background as the head of the policy committee for the Republicans in the House. I actually was also the national chairman of the American Conservative Union, founder of the Heritage Foundation, and chairman of CPAC. And so I am finding myself constantly looking at some of the positions that our movement takes today and trying to figure out how they square, with what our movement once was. So I am somebody who has not gone to see Hamilton, but I would spend a lot of money to go see a play on Madison. So that give you some sense of where I'm coming from. I would disagree a little bit on one area, and that I think is important. The Declaration of Independence, which we just celebrated, is aspirational and it's political. It's a political document. It lays out a case for an action. It lays out the grievances that impelled us to that action. But the Constitution is law. Constitution is the supreme law. Constitution is not a political document. It lays out not only the structure, but it puts limits on what government can do. Very specific limits, not only in the body of the Constitution, but in the last part added to it, the Bill of Rights. And I think it's too easy to look at the Constitution and dismiss it as something that, well, there was a bunch of old white guys a long time ago, and we don't have to follow their lead. So I would disagree on that point. I think, and I start from that because I'm a constitutionalist, and I am quite often surprised at the number of people I see in Congress or writing in publications who are strong, staunch defenders of the Constitution who seem never to have read it. When I would suggest that reading it is actually a good exercise to start with. One of the things that I've observed, watching my former colleagues on the Hill, is the constitutional mandates about what Congress is supposed to do, which are not in giving power to Congress, it's putting obligations on Congress. Congress is the way in which the people's will is to be considered, deliberated, and enforced. It is the way we mix the democratic process with our Republican form of government. And I have watched, appalled, this is aimed at both parties, at the extent to which members of Congress, House and Senate, both parties, ignore, in the name of tribal solidarity, the mandates of the Constitution, so that what Barack Obama did for a Republican is automatically wrong, and if the Republican president does it, well, it's just fine, and we understand why, and vice versa. And we are really not going to be able to live up to our constitutional mandates until we decide that party loyalty, which is all very nice and it's fun, and I went to Republican conventions and I waved the banners and I did all that stuff, but it's a game. They're clubs. They're private clubs. And what matters is our diligence in being true to the Constitution. So I want to talk about that in terms of the war power. I also want to make a point, and this, of course, goes a little bit toward what you said in terms of the role of law and other factors. This is not theoretical. This is not to have a discussion about the role of the Constitution in this or in that. This is not theoretical. We are now looking at a real threat, possibly, potentially, from Korea. There's been talk about pushing for regime change in Iran. And we have a president who you may support or you may not. That's irrelevant to me. But who I think even his supporters would agree tends to be impulsive. That is that's a dangerous proposition, and one that the founders had in mind when they considered where to place the power to send America's men and women into combat and possibly be killed. So, you know, one of the interesting things, I don't know, I'm sure all of you have read this, about when Thucydides wrote about the Peloponnesian War, one of the major parts of that was the discussion between the Athenians and the Melians. Here's Athens, the great power of the time, Melos, a small island that the Athenians were trying to take over. And what happened was, the people at the top, which you would call the executive branch in Melos, decided they weren't going to consider what the public, which would now in our country be represented by the Congress, we weren't really going to consider what the public wanted. They had their own causes, they had their own reasons, and they decided that, as big as Athens was, nonetheless, the Melians were not going to surrender. They were going to stand up, and they were going to fight, and they were going to go to war, and the Melians were slaughtered and enslaved. We have a constitution that ensures that the will of the people is considered through their representatives in Congress, who make decisions, hopefully through a deliberative process that considers the options, the ramifications, and so forth. And if the founders believed in anything, it was that you are not going to give the power of life and death for a country, as well as its citizens, to a single or small group of individuals. That is the founding principle of the constitutional system that we have. One of the things that has happened, unfortunately, is over a period of time, we have come to believe that presidents not only have primacy in deciding what to do about war, that their commander-in-chief means that when the proper authority, Congress, decides that we're going to go to war, that the commander-in-chief doesn't have to fight with 23 other generals to decide, what strategies to pursue, what the tactics are going to be. The commander-in-chief is in charge of conducting the military operations when some other body has decided we're going to go to war. So we have over the years, and starting with a very poor decision by Justice George Sutherland, who had been in the Senate from Utah, went to the Supreme Court, and in the Curtis Wright case, declared out of nowhere as dicta, not related to the case at all, that in foreign policy, the president has plenary powers. The president's in charge of foreign policy. That decision has been overturned by the Supreme Court repeatedly, starting with Justice Jackson's decision in the Youngstown case, most recently in the Zivotofsky case in 2013. The Congress does not surrender its power just because the issue on the table is foreign policy. And we seem to have forgotten that. I know a lot of reporters for the New York Times have forgotten that. I talk to them all the time about it. So, a few years ago, I was co-chair of a task force by the Constitution Project on looking into the war power. We had a pretty good group of people on that task force. It was bipartisan, but we had Jim Woolsey and Judge Pat Wald and Susan Rice and Mike Glennon and Harold Coe, who was then dean of the Yale Law School. And we looked at this, and I just want to very quickly summarize 3 key points that we came up with. Because this is something we all agreed on. Number 1, this is the summary, and I'm just not even going to read much of it. Number 1, Congress must perform its constitutional duty to reach a deliberate and transparent collective judgment about initiating the use of force, except when force is used for a limited range of defensive purposes. 2, the president must seek advance authorization from Congress for initiating the use of force abroad, except when force is used for a limited range of defensive purposes. And 3, the Congress should authorize initiating use of force abroad only by declaration of war or a specific statute or appropriation. You made the point correctly, that the authorization for the use of military force that we now have did not envision going into military combat against forces that did not even exist at the time that the AUMF was passed. So let me just, I want to get to the questions here. So I want to make just one more point, couple. One is that we have been seeing a consistent abdication over the years. You go back to Harry Truman and deciding that it was okay for the United Nations to decide when we were going to go to war in Korea. And there's been a fundamental abandonment of both our democratic processes and our Republican structure of government. And one of the ways in which we did this, I will say it was not when I was in Congress, it happened just 2 years before I got there, was the passage of the War Powers Act, which is clearly unconstitutional. Now, presidents think it's unconstitutional because it infringes on their powers. It's unconstitutional because it infringes on constitutional powers by giving a single person at the top of the chain the ability to send us to war for a limited period of time, after which you were absolutely correct. There's no way those of us in Congress were going to cut off the funds, when our troops were under fire. So we essentially surrendered that power to the president. So in closing, today we have, as I mentioned, we've got the threat potentially from Korea. We have the potential claims by this administration that we need to pursue regime change in Iran. We have strikes going on, military action that's outside the scope of the AUMF. So that's why I close with just, this is not a theoretical classroom discussion. Re-establishing the authority of the Congress of the United States to decide whether we're going to go to war is absolutely fundamental. Thank you.
Mr. McCarthy, would you like to respond?
Just a couple of points, and some of it is sort of off the track of the war powers. I don't deny that the Constitution lays out in an exacting way a lot of legal arrangements. But when I say it's a political document, what I mean is if you look at the Constitution as it is written and as it was originally understood, and then you compare it to American governance today, it's virtually what we have today is almost unrecognizable. There's a fourth branch of government, which the administrative state, which could engulf a lot of the powers, or has engulfed a lot of the powers of the other three, and in a way that is completely antithetical to the idea behind the Constitution, which was to have political accountability for political decisions. The way that happened was political. It wasn't legal. It happened because people took steps that were beyond the power and contemplation of the Constitution, and the system accepted it. And the remedy for it, the ultimate remedy in the Constitution for that sort of behavior is impeachment, which is wholly a political remedy, not a legal one, in the sense that you can be, and I can say this as a prosecutor, even though high crimes and misdemeanors are not necessarily indictable offenses, but you can have 1,000 provable high crimes and misdemeanors. The way the Constitution is structured, if there's not political will to remove the president in the public, such that you could get 2/3 of the Senate to vote for removal, it really doesn't matter as a legal matter whether the president has committed high crimes and misdemeanors. The question is political will under the procedures that the Constitution has laid out to enforce the Constitution standards. And I think while there are extremely important legal arrangements in the Constitution, to the extent they are breached, the remedy for that is largely political and political will. I mean, you can't, if the president decides to haul off and invade a country when there's no American interest at stake, it's not like you're going to be able to march into federal court and get a judge to order him not to, because then you quickly find out what the framers recognize, which is that the courts have judgment. They don't have the sword and they don't have the purse. They don't have any means without the cooperation of the executive to correct the executive. So I guess that's one point. The other point, just briefly about Curtis Wright, I think, going back to Jefferson, Madison, the framers, their position was that the executive was supreme in foreign affairs, except to the extent that the Constitution created exceptions, and that the exceptions were to be strictly construed. So I've never understood it to be a situation where the Congress didn't have war powers, and in fact, robust war powers. But in the main, the president conducts foreign policy. And I agree with you. I think it's vitally important that the Congress assert itself with respect to the war powers that it does have in the Constitution. But I don't think that that necessarily cuts against the idea that the president is essentially supreme in conducting foreign policy.
Yeah, well, I agree with a lot of what you said. Part of the problem here is enforcement and political will, and I'll come back to that in a second. But the founders did give the president some powers in foreign policy. The president can negotiate treaties, and only the president can negotiate treaties. Those treaties are nothing but scraps of paper unless the Congress decides, the president can decide who will be our ambassadors to other countries. But that's only something they could put on their wall and say that, I was once nominated to be ambassador, because it has no force unless the Congress decides, the Senate, So the powers, so I read it differently. The Constitution actually is very limiting in Article 1 is in the Congress. Article 2 is a really brief, article. And until recent years, fairly recent years, it was understood that these were not presidential decisions. So we disagree about that. I would say, though, and maybe we both agree on this, a lot of the concern rests on those of you in this room. And it rests on you because one of the fundamental problems we have is that so many members of Congress, House and Senate, simply have no clue what their obligation is. So that if you have very, very important national security concerns and the administration decides to come and share that information with members of the Intelligence Committee. I don't know if any of you are staff for the Intelligence Committee. The executive branch tells members of the Senate and the House who can come hear that information, and who they can share it with, and whether they can bring staff. The Congress of the United States, which has the authority to decide whether we're going to go to war and to set foreign policy, is told by another branch of government, who you can tell, who you can share it with. You can't bring your staff. You can't tell other members of the Senate. And Congress just accepts it. I'm on the board of a group called POGO, the Project on Government Oversight. And I gave a talk to a group of Senate staffers, Senate and House staffers one time, and was shocked because somebody got up, maybe one of you, I hope not, totally angry because they kept filing on behalf of their member of Congress Freedom of Information Act requests, and damn administration would not respond. And I just said, well, John Dingell never would have filed a Freedom of Information request. He would have said, get your ass down here. And so, there is an obligation here for members of the Senate and the House to decide. It's nice to belong to a political club. I belong to the Republican Party. I belong to the Kiwanis Club. I was on the bowling team. I belong to things too. But my oath, I took an oath, and my oath was to defend the Constitution of the United States, not to defend my political club. And so you're right. It has a lot to do with public pressure, and it's how the Congress responds, doing its job, even if the majority of your constituents say, well, we're going to run somebody against you, or we're going to primary you. Tough. If you can't stand that, don't take the oath of office. Don't promise you're going to obey the Constitution if you're not. So, we're not that far apart.
No, well, I feel impelled or compelled to say that I belong to the Federalist Society, but so far Dean hasn't made me take an oath, so I do.
I'll take an oath to the Federalist Society, all right?
But just to echo what you say, I think it's critically important that Congress as an institution protect itself and its prerogatives, and the government doesn't work unless it does. And as I said during the last 8 years when I was usually in disagreement with what the government was doing, and in the 8 years before that when I was often, but less usually, in disagreement with what the government was doing. As a journalist, I get to rant and rave and get peeled off the ceiling in my attic or the Office of National Review or wherever. But you don't have that luxury on Capitol Hill. You don't get to be a spectator, and that's part of the gig, I think, of being elected members of Congress and the staff that have to support them. If you don't protect the prerogatives of this institution, then the Constitution doesn't work. As much as we all admire it and as much as we all say that we would like to see it operate in the way that it was intended to operate, those of us who take that position, it requires not only accountability. The original understanding was that the branches were going to compete and keep each other in check. Yeah. And part of the reason that we end up in a crisis environment, I think, is that if you let other branches get on for a long period of time with getting away with this and that, you eventually get to a point where they're so convinced that they're not being checked that you end up with very weighty decisions being made outside the parameters of the Constitution, and that's when we have crisis. So I think it's absolutely essential, if this framework of government is going to work the way it was supposed to work and the way it is supposed to work, that this institution defend its prerogatives and be accountable.
Yeah, well, just one sentence, or maybe it's two. Remember, this is not Great Britain. In Great Britain, the executive is the government, not in the United States. The government is not the executive branch. You're the government just as much as the executive branch is. Both branches. So just remember that.
Okay, very good. We're now moving to the Q&A portion of our session here. We actually have a standing mic right here in the hallway next to the door. Please line up, and we will get to as many questions as we can. Just one quick, before we get to the questions, I just have one sort of broad question for both of you. It's obvious that both of you would consider yourselves in the Congressional War Powers camp, and with some obvious noted differences and distinctions. But what I often gather from the other side, the Executive War Powers camp, if you could call it that, is sort of objections on 4 levels. And some of them have been touched, and we don't have to go over them, but I just want to make sure that they're out there in order to balance our discussion. The first, of course, is the track record regarding formal declarations. More than 100 times, the United States has been involved in military skirmishes. We've only declared war five times in our history. Is Congress really needed or even desirable in this space? Another one is, of course, and Congressman Edwards did touch on it, the War Powers Act of 1973. We've been involved in several military actions of varying scales, and without any real effect from that resolution. Another objection from the pro-executive camp would be the idea that Congress is really unmanageable. It's too large and unwieldy, and it can't make the swift action that's required in wartime. And the last one that I think I often hear is, what is the congressional incentive? How can you convince Congress to really be more involved in wartime policy? So if maybe you could comment quickly on that, and then we'll go to our questions.
Well, I think as far as the track record is concerned, the first point and the third point that you made, I think part of the reason that we haven't had as many declarations of war is to the extent that we're dealing with emergent situations. I think even people who are staunch Congressional War Powers advocates accept the idea that if the United States is under attack or under the threat of attack, that the president has the power to respond. And to the extent there was any dispute over that, I think the Supreme Court resolved it during the Civil War or just after the Civil War. Mm-hmm. So I don't take I think even Rand Paul, who is probably as staunch a pro-Congress war powers guy, would accept the idea that when the United States is under threat, that the president doesn't need to wait for congressional authorization, the president can move. I don't see that at all as detracting from the importance of congressional war powers in situations in particular where we get remote from a real threat to the United States, where I think it's really important that the other political branch either lend its support or perhaps persuade the president that he's about to embark on folly.
Well, very quickly, I've already addressed the War Powers Act. Actually, in the Civil War, the power that Lincoln had was very specifically spelled out in the Constitution, which was an insurrection, to put down insurrection. As to Congress being unmanageable because it's not swift, most of the cases, including right now with Korea, what you need is deliberation. You don't need impulsivity. You need, there are times, when the fleet is right off the shore or whatever, when you have to act very, very quickly. But most of the time, what we're dealing with is not that kind of a situation. And the benefit of having a legislative branch with power is that you have thoughtful deliberation, you get input, you talk about it, you consider the ramifications. With 320 million people potentially at risk, saying let's see how we can move quickly is a recipe for disaster. And I think there are circumstances when you have to move quickly, but not most of the time. Finally, in terms of Congress being unmanageable, I mentioned that. Congress. What are the incentives? Jesus Christ, they're Americans. They care about the country. They ran for office. They took an oath of office. They said it's our country. We're going to keep it safe. What their incentive to do it right? Maybe if this is a question that bears asking because we're not seeing signs of incentives, then maybe those people ought to go back home and run a bakery or drive a truck or whatever, and get out of Congress.
Just along those lines, when we were attacked on 9/11, we had an authorization for military force in about a week, and we could have had it in a day. On the other hand, the next step on the trajectory, perhaps, Iraq, Congress ultimately wanted to vote to authorize that because there was at least a persuasion on the facts that were known or thought to be known at the time that it was important for the country to do at that juncture. When you get to Syria and Libya now, there's enough disagreement about whether we have real vital interest there that nobody even wants to discuss it. The Congress would just assume it went away. I think sometimes our presidents have wanted to assume that those problems would go away as well. But my point is, it may seem that Congress is unmanageable, but the fact of the matter is, when there is an obvious threat to the United States, Congress can get its act together real quick. Right. And to the extent that Congress seems to be unmanageable, maybe the problem isn't the unmanageability of Congress, but the fact that it's not clear that there's a vital American interest that's at stake.
Okay, very good. Let's go to our first question. If you could just announce your name and give your question.
My name is Devin Watkins. My question is hypothetical to Mr. McCarthy. If later today President Trump were to go and attack North Korea without any kind of congressional authorization in advance, would it be appropriate to impeach him for that?
I guess it would depend on the intelligence that, you mean if we didn't know anything more than we know now?
Yes.
I don't think I would be in favor of impeaching him, but I would think that it would be a colorable argument.
Okay, thank you. Congressman Edwards, did you?
Oh, he just asked.
Oh, I'm sorry.
But yeah, it would be, yes, it would be an impeachable offense. Does that mean, that the decision should be made to impeach him? I don't know. I mean, it would definitely be an impeachable offense.
Next question, please.
Hi, good afternoon. My name is Whaley, and I'm from William & Mary Law School. I would like to ask about unconventional warfare. That we know the form of warfare have been changed drastically over the past century. today we have a lot of warfare involving different like drone strike, cyber attack, disinformation campaign, commercial conflict, special operations that do not involve a large converge of troops and materials. My question to the panel is, when and how should Congress to have more close weighing on those untraditional form of warfare, and where should the limits to be set to limit executive power? Because a lot of those decisions in those areas require very immediate and versatile response. They still probably still have the very disastrous consequences as conventional warfare, and they can last a very long time. Thank you.
Yeah. My own view of it is that what matters is the degree of threat to the United States. And I don't understand, for example, the military concept of proportionality. I don't understand that to mean that if you're attacked in a cyber attack, that means that your response has to be a cyber response. I think if the threat to the United States is profound enough, it's the job of Congress working together with the executive branch to arrive at an appropriate response. And if it's a profound enough threat, I don't think that military force of any kind, proportionate or at least enough to quell the threat, is something that should ever be off the table.
Yeah, I would say that it's up to Congress to authorize the development of the program to resist and to fund it, and to put limits on it, and outside of that, up to the executive branch to figure out the flesh, how to make it work.
Hi, Chris Sundenu. Hello, Andy and Mickey. Andy, you talked about will of the people.
Pardon me?
You talked about the will of the people as a big factor, as it should be for members of Congress to consider in what they do. I'm particularly concerned about that when I think that something like a quarter of those who voted in the last election on both sides voted for socialist, someone who, to my mind, along with Sharia, believes in an ideology, more or less, that is one of the two that is the greatest threat to liberty everywhere. So my question is a little broad, and maybe it isn't exactly the focus of the talk, but I think it's important. I'd like to hear both your and Mickey's thoughts. What can we do so that in the place that especially our young people first hear about history, first hear about economics, that they're hearing the full story? They're not called Islamophobes. If they look at what Sharia is, they're not called someone who's an elitist or focused on their own goodwill when they talk about von Mises or Hayek. What can we do? What can we do with school boards? What can we do with wealthy donors? What can we do with legislation here in Congress, even though I don't necessarily believe in the Department of Education getting mixed up locally, but if that's what we have, how can we use money so that our young people understand the reality of the world and we don't end up having the will of the people not forcing members of Congress to do the right thing?
Well, I think a lot of what you mention is upstream of Congress and the law. I mean, what you're talking about are cultural factors, and I always think that if the thing that we have the privilege of in this country is to live in a country where we're supposed to have full, robust exchange of ideas. And if you're living in a society where the law is dragging the culture along rather than vice versa, you have an enormous problem. And what that ends up meaning is that until I can persuade people to see things my way, as a member of this political community, I have to accept the fact that a lot of things will go on that I don't like. And I have to continue to try to fight and to persuade, but I also have to be realistic about what it's possible to achieve, and particularly what it's possible to achieve through law. I don't think that the culture can be changed by laws that get enacted in Congress, and I think, this is after a lot of hard years of thinking about this and maybe seeing things differently when I was younger than I do now. But I think the more people look to this city to solve what's wrong with the country, the more they're looking in the wrong place, because it's the sort of thing that has to come from the ground up. It's not going to come from here.
Yeah, that's right. And I would just add one thing to it, and that is we have this little off topic, but we basically have turned our high schools, colleges, and universities into vote tech schools, where they're basically focused on how we help our young people learn how to get a job, which is an important part of it. But we don't teach them critical thinking, where they can look at various options and think critically about what their benefits are, what the dangers are, and so forth. So if you believe your position is right, and we all think, each of us think our positions are right, we should all want a well-educated society capable of thinking critically and evaluating the arguments they hear with confidence that when everybody thinks about it, they'll come out thinking just like I do. So, I do think education is an important part of it, but I do want to say, because I did hear, the examples you used, I don't think that it serves our country's purpose for us to try to have education systems that propagandize, into, to support of our particular point of view. I think socialism is a great policy for people going broke and starving, and but I don't know that we should preclude people being exposed to the idea and able to evaluate it. It's important that we maintain the essence of freedom of thought, basic liberties that are part of what distinguishes us from other countries.
Hi, my name is April Artrip. My question is, does the President have authority under the Constitution to refuel Saudi warplanes bombing Yemen without congressional authorization?
Does he have the
Authority under the Constitution?
I don't mean to go lawyer here, but I always, when I hear these questions, I always think of the distinction between power and authority. So I would say he has the power, but not the authority. And the way I would look at it is as follows. I believe that if there is not a threat to the United States, forget about imminent, or if there is not a threat to the United States, and the President wants to take military action because he believes it's in American interest, which implicitly you would think that would be his thought process if he's President of the United States, then I think he needs authorization from Congress. And just putting my prosecutor hat back on for a second, if you aid and abet a principal in committing an act, you are treated under the law, at least the domestic criminal law, as if you were the principal. So I don't really see a big difference between aiding and abetting the Saudis in carrying out attacks or directly attacking that other country ourselves. To me, it's the same thing, and since it's removed from obvious American interests, it would require congressional authorization to be authorized, but I wouldn't argue that the President doesn't have the power to do it. He's the Commander-in-Chief, and if you think he's abused his power in an unacceptable way, then you're talking about impeachment, really. There's not a lot. You can start by trying to cut off money and politically try to put pressure on him to stop doing something that's outside the Constitution. But if the President is hell-bent on doing something that's harmful and outside the Constitution, Congress's ultimate way to rein in a president is to impeach him, which obviously is not something we've ever done. So
yeah, it's also, well, we've impeached them, we haven't convicted them, but
we
have other ways we have other ways on other things, and that is to cut off funding for what presidents want to do, and to do it in a threatening way. I mean, you can simply, it doesn't have to be related to the issue. If you don't have a way to interfere directly with what the president is trying to do, you say, fine, but we just cut off all the funds for the executive office. have fun. You won't have a salary. You're nobody. I mean, Congress has a lot of power. If it exercises it, that would require kind of an extreme case. But the power of the purse is not a small thing. But there's something in your question, I don't know what it was, that prompted this thought, which is probably unrelated to everything else. But I think when you're thinking about making these kinds of decisions, you ought to remember that you're making them on principle, regardless of who's in the White House, what party is in power. So one of the issues when I was in Congress, this was funny, my party, the Republican Party, fell in love with two concepts. I think that they preferred these to even cure for cancer. I mean, it was everything. One was line item veto and one was term limits. And I said, well, wow, hey, those would be cool, right? Does it bother you that they're unconstitutional? Well, no. So the thing is, when I was in Congress, we had overwhelming Democratic majorities in the House and the Senate, and we had a Republican president. So we want to say, line item veto would give more power to the Republican president, and term limits would wipe out all these Democrats. I said, here's what if, not much chance of it, but what if someday a Democrat was elected president? Then what? And of course, then came Bill Clinton. But so I think we have to be really careful when we think about these things. What's the long-term principle, and how will it apply if it's being used against us?
Thank you.
Okay, we've got a couple more questions, and we're running a little short on time, but we'll try to get to all of them if we can.
David Wagner. One thing that may be causing problems today in applying the framers' war clauses, and this is not my own idea, the framers had read their Grotius and their Pufendorf and so on, and they may have thought of war as not so much kinetic operations on the field, but rather as a legal status between states. And that's why it's in Article 1, the lawmaking section. And once the relationship between states is defined, between two states is defined as one of war, all kinds of consequences follow from that. The president can get kinetic with them. Their ships are subject to seizure as prize, all kinds of things. We don't make war with states so much anymore. In 1941, we had that declaration: we're at war with the Empire of Japan. We're at war with the German Reich. And there should have been one for Korea. But since then, it's been what? The Viet Cong, the Al-Qaeda. We don't live so much in an era of wars against states. Iraq, but that Congress opted in a case where it had in its hands the power to define a relationship of war between us and a state, to instead give a very broad authorization to use military force that covered a lot more than just Iraq. I would hate to think that the war powers, the way Congress defined them, aren't applicable today. I always want to apply the Constitution as written, come what may. But is this a problem?
Well, look, you have a situation where you have an authorization for military force in 2001 that's still being used as a rationale for carrying out military operations under circumstances, as we discussed before, where some of the combatants it's being used against didn't exist at the time that the AUMF was enacted. And in fact, even though I don't think we regard Al-Qaeda as an ally, it's a fact of life that they are allied with factions that we're supporting. So to my mind, that's a classic example that if Congress doesn't assert itself and use its Article 1, one of the most important parts of this power that Congress has, exactly as you're describing, to set these legal arrangements, is Congress gets to say who the combatants are and who the laws and customs of war apply to. And if that's something that's not done, and you then decide that you start out from the premise that you're at war on terror, which is not an enemy, it's a method, right? You're you're asking for, confusion and conflict and a lot of the problems that we've had the last 15, 16 years.
Yeah, militarily, I think that's, I'm aware that the the word war, originally would impute all kinds of other things that flow from it. But I think that's a distinction without a difference. The war power includes engagement with an enemy, a conflict, and that whether we are going to do that, whether we're going to engage an enemy militarily, is a congressional power. And so the fact that the word war includes several other things attended to it, a lot of which, including seizing property, is all in the Constitution, and those are all, management of the military, who decides who can be an admiral or a general, who decides what to do with confiscated property in a military conflict. All of those are congressional powers. A president really has to scour hard to find something, except that, if he wanted to wear a uniform because he's commander-in-chief, he could wear a uniform like they do in some other countries and have stars on the shoulder, and he'd have 6 stars, because would outrank a 5-star general. But outside of that, that whether you call it a war or authorization to use military force, that's a legislative power, clearly.
Hello. My name is Avram Reisman. I work for an organization called Just Foreign Policy. I was originally going to ask about the Saudi refueling, but given that was asked, I have an additional question, which is, should the Congress have to authorize offensive use of nuclear weapons? Should the president have the ability to use, effectively, should there be a no first use policy as law?
I believe in, under the Constitution, I believe in congressional war powers and I believe in presidential war powers. Congressional war powers are to declare war and set the parameters for the conflict. I think it's up to the president to prosecute the war once Congress has declared war, and I don't favor any inhibitions in that regard.
Yeah, it becomes a difficult question if, for example, if this limitation had been in place in World War II and would have not allowed Harry Truman to use an atomic bomb too. And that's a very debatable point about that, but there would have been, many tens of thousands of Americans killed on the landing beaches in Japan. So, I'm inclined to think that when the Congress has declared that, yes, we're in conflict and we're fighting this to win, unless they specifically put a limitation, no, we will not have that, then it is the president's job to decide the tactics, strategies, and weaponry.
Thank you.
Hi.
Hi.
This microphone thinks I'm taller than I am. Hi, I'm Kelsey Myers. Thank you for speaking with us today. I wanted to ask you what your thoughts were on Senator Franken's 2011 Pay for War bill. At the time it was introduced, it was a real problem and still is that though Congress has the power of the purse strings, many wars are what some people would say put on a credit card through emergency spending bills and international loans. This bill allowed any expenditures outside of the day-to-day defense budget for a new war to be paid for, and they couldn't be paid for without increasing the on-budget deficit. And it allowed for a waiver in case of emergencies, and current wars were exempted from it so that the operations would not be disrupted. And the idea of this bill was to encourage the American people to feel further incentivized to speak with their elected officials on their feelings about wars by making them both more financially responsible for wars in addition to personally responsible through their connections with veterans. And then the idea was that they'd become more involved in the congressional deliberation process, and furthermore, that this congressional deliberation process would therefore then have to be more transparent and open so that the power of the purse strings would once again become something a little more meaningful to the overall conduct of wars in the United States. So my question is, what type of impact do you feel that legislation like this would have on the executive and legislative war powers? And do you think it would significantly impact Americans' support for wars, which you discussed was so important to their success?
I'm in favor of anything that is reflective of Congress using its power of the purse in the military context and doing it in a way that's transparent. I'm not smart enough to figure out like what all the unintended consequences that, you know, if we do this, then someone will think this and then they'll be more responsible in this way. But I do think to the extent that you propose legislation that makes it clear what it's costing us to fight in these conflicts, it makes it much more likely, or at least more likely, depending on how effective the measure is, that military force is going to be used only for vital American interest. And my own personal view is that that's what it should only be used for.
I hate to have any disagreement with Al Franken because he's the giant of the Senate. Well, I think there are several factors. One is, I think war is one of those circumstances where real people get killed. And I don't think we should be making our decisions about whether to go to war or not because of what it's going to cost. If it is something that is a matter of, you should not go to war unless that's something that's really important, and non-debatable almost, national interest. You don't go to war willy-nilly. And if it's a war that you would not go to if it costs too much, then you shouldn't be going to that in a war at all. I also don't like the idea of one Congress, tying the hands of a future Congress. The whole idea is that you are able to sit down, deliberate with the circumstances that you have at the moment. So, I have no problem with saying we want to know as we do this what it costs, what do we anticipate the cost would be, but that should not have any bearing on whether you decide to go to war or not.
Yeah, see, I don't know that I'd agree with that. I think that how much it costs is part of the equation of what your interests are. I'm not saying it's the dispositive one, but I do think it's a factor. And we are in the business of weighing whether a particular interest is important enough to go to war over. And since there are a number of considerations that go into that, I don't see that the financial one shouldn't be one of them.
Okay, we are running real short on time, but let's try to squeeze it in if we can. Please go ahead quickly.
Hi, I'm Louis Lavrone. I'm an attorney with the Financial Integrity Network. I wanted to revisit two examples that have come up a couple of times over the course of this discussion, the entry into the Korean War and the War Powers resolution, to try to use those to tie together sort of an underlying question we haven't directly addressed yet, which is, while Congress has a power under Article 1 to declare war, we haven't really discussed whether there are any limitations or requirements on the form and content of a declaration of war. So using those two examples, could you briefly explain what exactly a declaration of war actually has to contain or cannot contain? For example, why were those two examples unconstitutional, even though there was, with the War Powers resolution, sort of a blanket authorization limited by time to use the armed forces? And in the case of the Korean War, the UN Participation Act contains a section that does authorize the president to carry out UN Security Council resolutions. And I'll leave it at that.
To my mind, an authorization for military force, a declaration of war, there's no talismanic formulation. Authorization of military force is fine. And to me, it's like other congressional legislation, which is to say you cannot, by legislation, attrit the president's powers. So I don't think you could have, for example, a declaration of war that told the president how to prosecute the war, because that would be a usurpation of the commander-in-chief powers. But short of something like that, I don't believe there are any limitations on what Congress can do.
I agree on both points. One is that the Congress has the authority to decide whether or not we're going to engage in conflict. I think a UMF was a perfectly fine way to do it. I don't think it means that you have to use these specific words. It's a power. It's it's not an English test. And then the other. But then on the Korean War, a treaty that violates the Constitution that provision of it is unconstitutional. The United Nations and no treaty, no president, can sign and no Senate can approve a treaty that is in violation of provisions of the Constitution. It can violate statutes, but the Constitution is our supreme law. So if there's absolutely no grounds that you can think of, in my mind, that would say that a UN treaty, gives the president the authority. So we've had something that the Swiss and the French and the Belgians and everybody all come together and say, yes, you can go to war. And so we're going to send our people to go get killed. I mean, let's not forget, war ain't a game. Those are body bags. And we don't leave that to other people to decide whether we're going to do that.
Thank you very much.
Okay, hopefully it's a yes or no question, but you've waited very patiently, so please go ahead.
Connor White from Congressman Warren Davidson's office. What role do the courts play in all of this in terms of both power and authority to get involved? And just they seem to have more political capital than we've seemed to acknowledge tonight or today.
And also, if you would maybe offer your concluding thoughts, that would be great.
Oh, sure. Well, I'm glad to get the question about the courts because if you would ask the question a little over a decade ago, the answer would be probably very different than it is today. Justice Jackson wrote a decision in a case called I think, Chicago and Southern, around 1944, 1946. It escapes me. But it's one of the best articulations of what the framers had in mind in the distribution of power in different areas of the Constitution. And what he pointed out was that the most important decisions that a body politic makes are decisions about its national security. So that in our system, those decisions are supposed to be made by the political actors who are accountable to the people whose lives are at stake. So for that reason, they're not judicial decisions, as he pointed out, not just because there's nothing about being a lawyer, even a judge, that gives you institutional competence in areas that are relevant to war making, but also because our basic system is supposed to be that these decisions get made by Congress and the president because they answer to the people whose lives are at stake. And for that reason, I think for a very long time, and wisely so, there was no real judicial role. Things are different now because we're involved in a different kind of conflict. So that even though we have an enemy in al-Qaeda, for example, that attacked us in a way that foreign sovereigns were never able to attack us on the homeland, at least the continental homeland, I think it's kind of an admirable thing about the American people that even though logic says terrorists who attack civilian populations should have less rights, we always want to make sure that we got the right people. And because terrorists, unless you catch them in the act, present as if they were ordinary civilians and not combatants, we've layered onto this war an unprecedented amount of due process for enemy combatants. To my mind, it's gone way too far. I mean, when you get to the point where in the Boumediene case, they say that enemy combatants have constitutional habeas corpus rights, so that what you're essentially saying is that the Constitution is a weapon that the enemy can use against the United States, that you can bring the people who prosecute war in our system, the enemy can bring those people into our courts. To me, that's gone way too far. I'm okay, I wasn't at the beginning, but I'm okay with the idea because it's a political reality. The public wants to make sure that we're holding the right people. So I'm okay with the idea of there's a modicum of due process that's allowed in order to make an evaluation about whether somebody actually qualifies as an enemy combatant. But if it gets to courts like ordering the president to release people, or it gets to courts telling Congress after the court has invited Congress to come in and make a system for detention and trial, Congress actually does that at the court's behest, and then the court comes back and says, not good enough. I think it's gone way too far.
I just add the thought that habeas corpus is a fundamental constitutional principle, and it is something that our government does or does not do. And under the Constitution, the right to habeas corpus, is fundamental. The United States, I don't know how many of you believe in American exceptionalism, but I do. I think we are different. We don't lock people up and hold them forever without knowing that they're guilty. We just don't do that. And one of the things that's happened in this so-called war on terror is that we have become very good at capturing and locking up and punishing people who have committed war against us, and also locking up and holding people that we don't know were committing war against us, because they were there. And we have to be really careful. It's too easy. It is too tempting to say that our constitutional principles they're kind of inconvenient at times. And I think we just have to be real careful that we don't just say, well, let's give them up. Let's become, any other country. Do it. We've seen them do it. Why don't we do it? And I'm bothered by that. I grew up believing this country is different, and its rules are different, its principles are different, its values are different. I'm just really reluctant. I would much rather let one guilty person go free than have somebody who did not commit a crime, be punished. And I just think, some of those fundamental principles are important to remember. It would be too easy to follow the path of all these other countries, and we could start naming them, and I won't, but I mean, other countries that to ensure that whatever they were trying to ensure, could just simply set aside the rules, and we can't do that.
Okay, very good. I think we'll have to leave it there. Thank you, gentlemen, for a wonderful discussion. If you'd like... Lastly, if you'd like to learn more about the Article 1 initiative, please visit our website, fedsoc.org/Article I. We've got new papers out in the Harvard Journal of Law and Public Policy, and we've also launched a podcast called Necessary and Proper, available on Google Play and iTunes. Thank you all for coming.